All right. Thank you all for being here. My name is Matt Pizik. I'm the executive director of the Oregon Trio Association. So we are a nonprofit organization that works with the 54 different Trio grants all throughout Oregon. And it is my absolute pleasure today to be joined by a bunch of wonderful law students connected through the Oregon Bar Association who reached out and wanted to do something for our students and families, and particularly the parents of our students. And a lot of the feedback we got from programs is that many of our students come from low-income families, and with the inflation, housing crisis stuff that's going on in Oregon, like most folks are renting, and we really could use a lot more information about just renters' rights, landlord, tenant law, just equipping folks with more information so they can advocate for themselves. So that is what these wonderful folks have put together today for us. So just briefly here, I'm going to do it again since I'm now officially screen sharing. But if you are watching the recording of this, if you're not joining us live, you have already found this location. But I want to highlight some other items as well. So on our website, OregonTrio.org, under the events tab, there is a renters' rights workshop. This is where you will find the recording that you are either watching right now, but it also has all of the workshop materials, so all the handouts in both English and Spanish, as well as the presentation slides that they're going to be going through in just a moment here. So feel free to utilize those and reference those for yourself. With that, I'm going to stop my share and go ahead and pitch it over to you all to take it away here.
Thanks, Matt. And since I have the first portion here, maybe I'll screen share my portion and then hand over to my co-presenters when it's their turn. And if folks can confirm that they're seeing our slides here.
Yep, we can see it, Diane.
Awesome, thank you.
Yep,
Good. Thank you. Good evening, folks. Welcome to this workshop on landlord tenant law, and thank you to the Trio folks for hosting us and for everyone present for joining us. We have a lot of materials to cover here, so we're going to dive right in. Oh, I guess by dive right in, I mean we're going to start by introducing ourselves. So actually, we'll take this opportunity to introduce ourselves and as well also provide an overview of the topics that we're going to be covering during this workshop. My name is Diane Nguyen. I use she, her pronouns, and I'm a staff attorney with Legal Aid Services of Oregon, which is a statewide nonprofit organization that provides free legal services to low-income Oregonians. And today I will be covering the termination and eviction process. And I'll pass it over to my co-presenter, Amanda, to introduce herself.
Hi, I'm Amanda Bryan. I use she, her pronouns. I work at a law firm in Portland called Bullivant House or Bailey. I do all kinds of different law stuff, and I'm going to be speaking about security deposit.
Good evening, everyone. My name is Stephanie Grant. I'm an attorney at a private law firm called Tonkin Torb. I'm going to be speaking this evening about fines and fees.
Everyone, my name is Kate Shakely. I'm an attorney here in Portland, and I will be doing a presentation about eviction expungements. Thank you for being here.
All right. So thank you, folks. And then as mentioned, I'll start us off by going over the basics of terminations and evictions. And in the course of that, I will also be highlighting some important changes to the eviction process as a result of a pretty recent legislative change. On March 29th of 2023, the governor signed House Bill 2001 into law, and that provides tenants with some pretty key additional legal rights that we want to make sure that folks are aware of. So in the following slides, I've used the pointy green new icon that you're seeing on this slide to highlight some of those HB 2001 changes. All right, so what folks are seeing here is a basic overview of the termination and eviction process. And sometimes those terms get used interchangeably, but it's important for those of us who work in this area of law more often to be able to actually use those terms distinctly, because that's helpful for us to identify where a tenant may be in the eviction and termination process. A very basic but important and often overlooked aspect of this process is that when a landlord wants to get rid of a tenant, they must first serve the tenant with a written termination notice. And under Oregon law, when I say written, what I mean by that is the old-fashioned physical document that gets handed or sent to the tenant via first-class mail. And that does not include verbal notification, email or text notification, some of the more, I guess, 21st century methods of communication. So under Oregon law, if the landlord is saying verbally or if they're emailing or texting this notification of termination, those would not be valid, and that would give a tenant a defense to the eviction. The notice must be given to the tenant in certain ways to be legally valid, and depending on the type of notice, it must also contain certain information to be legally valid. In the next couple of slides, I'll talk more about that. But just to kind of go back to the process that we're talking about here. Step one, a termination notice is given. Every valid termination notice must state a date by which the tenant must vacate or move out of the rental unit. And once a tenant receives that notice, the general options are they can negotiate some sort of settlement with the landlord in order to stay. They can move out before the vacate date, or they can stay and choose to fight the eviction in court. Now, if the vacate date that's stated in the termination notice comes and goes and the tenant still remains in the unit, then we're moving to step two, where the landlord must file an eviction case in court in order to remove the tenant. Under Oregon law, a landlord is prohibited from engaging in what we call self-help or extrajudicial eviction, which is essentially for them outside of or without having obtained a order from the court, for them to engage in acts to pressure or force the tenant to leave. For example, they can't just show up and change the locks or throw out the tenant's belongings or shut off the utilities without going through this court process of eviction. And if the landlord engages in any of those activities, the tenant may sue them for illegal lockout or ouster. And so the tenant's options at this point, after an eviction case is filed and the summons is served on them, are essentially the same. They can try to settle the case, they can move out, or they can stay in the fight. After this eviction case is filed, the tenant will receive the summons and the notice from the landlord and from the court that tells them when their first court date is. And that first court date, we're at step number 3 here, is called the first appearance date. And it's very important that a tenant shows up at first appearance, regardless whether they've settled the case or they've moved out. Because if they do not show up at first appearance, they risk having a default judgment entered against them, which, to put it simply, is like having an automatic win for the landlord. So if the tenant shows up at first appearance and they're not able to settle the matter with the landlord, then this case is going to be set for trial. In order for the tenant to have trial, they're going to have to file a document that's called the answer. That's number 4. The answer is essentially the tenant's response to the landlord's complaint, which was a document that the landlord had to file in order to initiate or to start this case. So at step 5, if there's trial that happens, if the tenant wins, then they get to stay. And if the landlord wins, then the tenant generally will have 4 days to move out. And after which, if they are still not out, the landlord can go back into court to get a court order for the sheriffs to come out and lock the tenant out and remove them. And then I noted here that this last chance to redeem a tenancy in non-payment cases. In an upcoming slide, I'll talk more about why it's important for us to kind of just know where we are in the process and why I'm noting that right at the point of trial is important. Okay. So to circle back to what I mentioned earlier in the slide, termination notices must be given in certain ways. These are the 3 methods under Oregon law that are proper methods of service that makes the notice legally valid. First, the landlord can personally deliver the termination notice to a tenant. That's essentially a hand delivery by the landlord or the agent to the tenant. Or the landlord can send it by first-class mail. It's important that it be sent by first-class mail as opposed to, for example, certified mail or registered mail. Sometimes folks think that doing that ensures that this recipient will have it and then they have proof for court that this notice had been sent. But actually, under Oregon law, the weird quirk is that if you do that and you don't actually send it by first-class mail, it actually invalidates the method of service. And if the method of service is first-class mail, then 3 days need to be added to the notice period. So if the landlord is saying you have 30 days to vacate, they're going to need to add 3 extra days to that 33 days to vacate if they're using first-class mail as the method of service. And the last method of service that the law allows for is what we call post and mail. or nail and mail, which is where the landlord posts a copy of the notice on the entrance of the rental premises, and then they also mail by first class mail a copy of that notice. And that last method of post and mail is only allowed if there's a written rental agreement between the landlord and the tenant. And that rental agreement allows for this very method. And also that this method is in the rental agreement, it states as a reciprocal service method, meaning that the tenant can also use this method to serve any notice onto the landlord. And then I also mentioned that termination notices must contain certain information to be legally valid. There are different types of termination notices, which all have different technical legal requirements. So, but what's common between all the types of termination notices is that they must state an issue date, which is the date that the landlord gives the notice to the tenant. They must state a vacate date, which is the date that the tenant must move out by in order to avoid an eviction case being filed against them. And then it must state information for veterans. And then depending on the other types of notices, there are other types that might be required to state a chance to cure the alleged violation, or relocation assistance money must be included with it. So the types of notices and the specific requirements are outside of the scope of the presentation, but hopefully the takeaway for folks is if they're faced with a termination notice, they're going to look into what legal requirements are tied to those types of notices and start seeking legal help and legal advice as early as possible. Okay, so although we're not going into depth about the different types of termination notices, I do want to talk a little more about non-payment of rent, because that's the majority of eviction cases that we see in court. And also House Bill 2001 brought about important changes to the requirements for termination notices in this type of case. The first is that previously landlords in most cases are able to terminate a tenancy with as little as 72-hour notice. Currently, they are required by and large to provide at least 10 days termination notice. And then I note there on the side the two instances in which there might be more time or less time that may be required or may be allowed. And due to shortage of time, I'm not going to read all those, and then I'll move on to the next slide. All right, another notice requirement here is that every non-payment termination notice and summons must include a notice like what you see on the right here. If the landlord serves the non-payment termination notice or the summons without including the notice on the right, that would be grounds for the court to dismiss the case. Next here is what a sample non-payment eviction timeline looks like under current law compared to prior law before House Bill 2001. An eviction case for non-payment could move as quick as it gets filed early this week and trial happens late next week. Under current law, which requires that certain minimum number of days happen before the next proceeding can be scheduled, a trial could be pushed out by almost a month and a half here. And then just to kind of breeze us through some things here. The right to redeem, I do want to take a little time cutting into Amanda's time, I'm sorry. The right to redeem is pretty important here. New right for folks, because before the passage of House Bill 2001, a tenant's last opportunity to redeem or to save their housing by paying the amount of money that's stated in the non-payment termination notice would be the last date before would be the date that the termination notice expires. So in this timeline, let's say a termination notice is issued on the 8th, because the soonest that a landlord can issue a 10-day termination notice is the 8th day of rental period. And for most folks, rent is due in the 1st, so the 8th day of rental period would be the 8th of the month. 10 days pass, that would be the 18th of the month. Under old law, the 18th of that month on the left would be the last opportunity for a tenant to pay the amount of money that's owed in order to save their tenancy. Even if they say on the 19th, the landlord files the eviction case at 10 a.m., 12 p.m., tenant has the money, wants to pay it off, landlord has the right to reject that money and insist on evicting the tenant. With the change of House Bill 2001, now the chance to redeem, the last opportunity for the tenant to pay, is up until the day of trial. If they're able to pay it off, then the eviction case should be dismissed, although the landlord may still charge a filing fee to the tenant, but that wouldn't be a prerequisite to dismissal of the case. All right, think I'll hand it over to Amanda for security deposits. Do you want me to stop screen sharing so that you can share?
Sure, I'm getting a warning that my microphone isn't working, so I apologize if my microphone isn't working. Okay. Let me just get this all settled. Okay, thank you, Diane. I'm Amanda, and I'm going to talk about security deposits, and hopefully this is working. So a security deposit, if you've rented before, you're probably familiar with this, but in the very beginning, before you move in, the landlord can require you to pay a security deposit. It's an amount of money that the landlord has to hold on to while you live in the place. And then when you move out, the landlord can use some of the money for certain things that we'll talk about in a minute, and then has to give the rest back to the renter. So a security deposit can include just certain specific things. It can include damage. So if you have extraordinary damage when you move out, the security deposit can be used to pay for that damage. It can be used for carpet cleaning. It can be used as a last month's rent deposit or a prepaid rent deposit, sometimes called, and it can be used for a pet security deposit. So what it cannot include is an extra deposit for a service animal or companion animal when the renter has a disability. So before you move in, it's important that you know what that security deposit is. So you're going to check the lease agreement and the rental agreement, and it needs to say what that security deposit is, the amount that it is, and what it's going to be used for, whether it's the last month's rent, pet deposit, security deposit, for damage and cleaning. It needs to say if it's for carpet cleaning also. And then you need to get a receipt, and you give the money, get a receipt back, so you know you have a record of that. In the first year that you live in the place, the landlord cannot increase the security deposit unless you make a change that would have increased the pet or the security deposit anyway. So for example, if you get a new pet, then the landlord can ask you to pay an additional fee, and that's all right. But if nothing changes, they can't ask for more money during that first year. After the first year, the landlord can require an increase in the security deposit. But if they do, then they need to give the renter 3 months to pay that increased amount. The next slide is going to talk about domestic violence. So if you need to take a break, it'll be about 15 to 30 seconds, and we'll be back talking about regular security deposit stuff. So in certain cases, if you're in a domestic violence situation and the abuser is removed from the lease, sometimes when you remove someone from the lease, it can cause the security deposit to increase. But in the case of domestic violence, when that abuser is removed, the security deposit cannot increase. You may have to prove that to your landlord, show some paperwork that it should not increase. Okay. When you move out, the landlord can only use the deposit for certain things. We talked about that already, but now I'm going to say what things. The landlord can use it for unpaid rent. So if the renter didn't pay the rent, they can take that from the security deposit. They can pay for repairs beyond normal wear and tear. We'll talk about that in a minute. They can use it for cleaning. And this is kind of tricky because they can charge you for cleaning, but they don't actually have to pay for cleaning. So it's a little bit wonky. We'll work on that with maybe the next house bill. It can also be paid for lost. It can also be used to pay for lost rent during the repair or cleaning. So if it took a couple of weeks to do those repairs, then that rent that the landlord lost can be taken from the security deposit. And it can also be used for carpet cleaning. Whatever is left from that is returned to the renter. It has to go back within 31 days, and there has to be an explanation of what that money was used for. Normal wear and tear is a tricky one too. There's no legal definition for what normal wear and tear is, but it's sort of this squishy gray area. But you can see in this comparison, we have normal wear and tear on one side and extraordinary damage on the other. This is really clear. One is going to be normal wear and tear, and the other one is something that the landlord could use the security deposit to pay for. When you move out, if there's damage to something, then the landlord can use the security deposit to replace, but not to upgrade. So for example, with this refrigerator, you can replace the same refrigerator, but you can't get the new fancy one. There's also, when you move out, you'll have lived there for some time and used that appliance. A refrigerator will be used. So if it's not a replacement for a new refrigerator, it'd be a replacement for the 10-year-old refrigerator if you lived there for 10 years. So carpet cleaning is another tricky thing. It can't, if you moved in and the carpet was new, or you just had it cleaned before you moved in, then the landlord can charge for carpet cleaning. If they didn't clean it before and it's old, they can't charge you. The rental agreement has to say it's going to be used for carpet cleaning, and then it has to be an actual carpet cleaning. It can't just be a vacuum or a, even sprinkling the powder. It has to be a shampooing machine or a carpet cleaning machine in order for the landlord to charge for it. And I'm going to talk about domestic violence one more time, last time. When you move out, if there's damage that was related to the domestic violence, the landlord cannot use the security deposit to pay for that. And that is another thing that you may have to bring in some paperwork to show that this is related to domestic violence, but it shouldn't go against your security deposit. So the important stuff, how do we get more of your deposit back? I've moved into a lot of apartments and I never get my full deposit back, but there's some tricks that we can use. First of all, before you move in, sometimes the landlord will give you this, and sometimes, but if they don't, you can download one of these reports from the link that we saw earlier. It just will list all of the brooms and all the different things, and you write down what damage you see. So the damage that is pre-existing, so that when you move out, you can say, this was already here. I didn't cause this damage. It was already existing. It's really helpful if you can take a picture of that damage, and especially if you can date the picture so that you know that when you moved in, that damage was existing. If you don't have a way to date the pictures, which that's smarter than I am, but you can email it to yourself, and that will, the date of the email will show that that was when the picture was taken. So it's an easy way to date it. When it's time for you to move out, it's very important that you give proper notice. Your rental agreement will have an amount of time. It's often 30 days, sometimes it's 60 or 90 days. So you need to make sure that you give the right amount of time, notice to your landlord that you'll be moving out. Sometimes if you don't give enough notice, the security deposit can be impacted. You also want to make sure that you give all your keys back, because that can be an automatic deduction from your security deposit. You want to make sure that you give the correct address for where you're moving to so that the deposit can be sent to you. Most of the time it's going to be mailed, so they need to have the right address. And then you also want to make sure that you clean the apartment or home to the level that it was when you moved in. A lot of times it'll be broom clean, but you want to make it as clean as it was when you moved in, so you don't get a charge for cleaning. If the landlord does not give your money back, then we have you wait 31 days. Once that 31 days has passed, you send them a letter. And in the materials, there's also a sample letter that you can use that just says, here, this is the date that I moved out. I expected the security deposit to be returned to me within 31 days. It wasn't, and I will give you a certain amount of time. 10 days is a good amount of time to return that to me. You'll give them the address that you want them to send it to, and then you'll send it, just like Diane said in the previous section, send it by regular first-class mail, not certified, not registered. If they still don't give the money back within that time period that you give them, then you can take them to court, and you go through small claims. So you don't need a lawyer, and you can file through the small claims court. If the landlord takes too much of the money, which sometimes happens, then we start the process with a letter again. And the letter needs to explain, and there's a sample letter in the materials for this as well. The letter will need to explain what you thought was too much. So, for example, they'll say that we took 100% of your security deposit to repair a hole in the wall. And you think that, let's say that the security deposit was $1,000 and they said that it took $1,000 to replace this hole in the wall, and you know that that's too much. So you need to figure out what you think it would cost. And the way that you can do that is by talking to someone around and getting an estimate of what they think it would cost to repair that hole in the wall. And then you say it should be $150, not $1,000. So you'll include that in your letter, send it to the landlord. And while you're doing this, you're going to want to be collecting all of that information just in case you need to end up in court again, small claims court. So you'll collect all of the invoices, any bids, any estimates you can get from any professionals. You'll also take that checklist that you prepared in the beginning so that you can show if you're being charged for damage that you didn't create. And then you'll get all of those pictures, and you can take pictures from when you moved in, and then you can take pictures when you moved out, so that you can show the damage that was or wasn't there when you moved in and moved out. And so that's all I have about security deposits. So I'm going to turn the time over to Stephanie.
Hi, everyone. My name's Stephanie, and I am going to talk a little bit about fines and fees. Can you all see my screen? Yes. Okay. Seeing some nods. So fines and fees are basically anything that the landlord tries to charge you that is not your monthly rent and is not the security deposit that Amanda just talked about. So if they say, oh, I'm charging you an extra fee because I had to do this and this, that's what this section is going to cover. Fines and fees have to be allowed by a written lease agreement. So if you don't even have a written lease agreement with your landlord can't charge you any extra fines and fees other than your rent and your security deposit. So the first thing you're going to want to do is, if your landlord tries to charge you something other than those two things, is think, do I have a written lease, and is what they're trying to charge me allowed in that lease? So this is a list of fines and fees. They're sort of interchangeable for practical purposes, but there are some nuances in the statutes and rules. These are a list of things that if they're in your lease agreement, then your landlord can charge you without giving you a warning. And some of them have maximum limits to the amounts. So screening means like screening your credit for your application. They're allowed to charge for that. Late rent, there are some limits to this as well, as far as how what a percentage of the rent it can be. And a bounced check for paying your rent, they can charge up to $35. For if you tamper with or break a smoke alarm, they can charge you up to $250. Breaking the lease, meaning moving out before you're allowed to, they can charge you up to 1.5 times the rent. So this is kind of a big one. A pet violation, meaning you have a pet and you're not allowed to, they can charge you up to $50, and that's in mobile homes only for some reason. They can, if they allow you to pay your rent through a method other than a credit card, so like a check or cash or money order, and you pay through a credit card, even though there are other methods, they can charge you a credit card processing fee. And credit card processing fees are usually between like 2 or 3%. So that's going to increase the amount you have to pay. I have question marks here next to renters insurance and for homeowners associations, because there are some really specific rules about, how much renters insurance they can charge you for, whether they can pick the insurer for you. Homeowners associations are also some more detailed rules that we don't have enough time to get into for purposes of today's presentation. But if you see in your written rental agreement, either of these red flags, like a requirement that you have renters insurance while you live there, or a requirement that you pay any portion of homeowners association fees, you're just going to want to ask some follow-up questions of your landlord and maybe do some Googling about whether or not they are allowed to charge those things under your circumstances. There's another list of fees that they can only charge you for after they've given you a first warning. So a late utility or service payment, if you're responsible under your lease for the utility payments and you're late, you're late one time and they say the next time you're late, I'm going to charge you a fee, then they can charge you that fee the next time, but they can't charge you the first time you mess it up. And these are just other examples. So not cleaning up pet waste, leaving garbage outside, which is different than, leaving potted plants or kids' bikes on the front porch. It's got to be trash. Parking violations, other vehicle violations like speeding through the parking lot, smoking violations, and unauthorized pet violations. So these are ones where you have to get a warning, but you should know also that sometimes the fees, let's say after the first warning, they charge you $50, they can increase the fees with repeated violations. But these still have to be permitted in your written rental agreement. So if these are not in your written rental agreement, the landlord cannot charge you even if they give you warnings about it. Other things they can charge you for that aren't exactly fines and fees are the property damage and the replacing keys that Amanda just talked about, things that they can withhold from your deposit. So that's sort of a different category that I think Amanda covered well. I think the one thing I didn't hear was disasters are not usually considered wear and tear. So that's something that if the landlord tries to charge you for replacing carpet after a flood, that's not something that they can charge you for. So pretty much anything else is off limits. Landlords, the reason these rules are in place is because landlords used to try to charge, the postage for sending you an eviction notice, or for noise complaints, or because they thought you were too messy with all the kids' bikes on the front porch, even though it wasn't garbage, cleaning fees, for having to clean up after, accidental events and things like that. So unless it's one of those things that Amanda talked about that they can withhold your deposit for, or any of the things that we've talked about in this fines and fees section, they're really not allowed to charge you, even if it is in your written lease agreement. So what happens if your landlord charges you a fine and you don't pay it? Well, they have to give you 14 days to pay whatever they're charging you. So that is step one. If you don't pay it within 14 days, then it is possible for them to send you a 30-day eviction notice, which is a little bit longer of a notice period than Diane mentioned in her portion of the presentation for an eviction for non-payment of rent. So you get a little more time if you're getting evicted for not paying your fees. And if you pay, even if you're late, they can't evict you for not paying. They can't evict you for the violation that they charged you the fee for. So I said that's sort of messy, but to clear it up, you either pay the fine or get evicted. So let's say you get charged the fine for leaving trash outside. They can't, if you pay the fine, they can't evict you also for leaving trash outside. You sort of pick your poison. If you think the landlord has charged a fee that they are not allowed to charge, you should pay the fee, but you can then sue them for either 2 times the amount of the fee that you paid, you get back, or $300, whichever one is more. You also might be able to avoid paying the fee and suing them later if you just ask some good follow-up questions, like show me in the lease where it says you're allowed to charge me this. So this is just sort of a summary slide of kind of your decision tree when your landlord comes to you and tries to charge you a fee. Step one is always going to be check your written lease. If you don't have a written lease, then the answer is no. If it's allowed by your lease, you can either pay or don't pay and risk the 30-day eviction. If it's not allowed by your lease, I have a little bubble here that says ask, because you definitely, it's a lot better to open up that communication and say, hey, I don't see where this is allowed by the lease. How are you allowed to charge me this? Before you go ahead and try to initiate legal action against your landlord to get your fee back, or your $300. So that is it for my portion. I'm going to stop sharing my screen and pass it on to Kate.
Thank you. Let's see if I can make this. All right, can everyone see? Okay. All right. So thank you so much for being here. Okay, this is weird because the screen is right here and the camera's right here. So my name is Kate Shakely. I'm here to talk about eviction, Oregon eviction expungements under Oregon Revised Statute 105.163. So before we start, what exactly is expungement? Well, expungement means that your records are sealed. They're technically supposed to be erased, but there's some obstacle that there's some companies that buy records from the Oregon government, and then it's there. But it's supposed to be that you're supposed to seal the records so future landlords can't search those records and see that you have a prior eviction. On the application, if they ask whether you've been evicted before, if you were successful in erasing your records, then you can just answer no, and that would be a truthful answer because the records are erased. It's a free and easy process. So by Oregon statute, you don't have to pay to get your record expunged. If you're not hiring a lawyer, which is not a process that requires a lawyer, it's a very easy and simple process. So you can do it yourself. So under Oregon Revised Statute 105.163, just as background, before we had ORS 105.163, there was no really eviction expungement process in Oregon. What we had was a law that Oregon landlords couldn't, under some circumstances, they can't look at your past eviction records and value that whether they want to accept you as a tenant or not. Now, in practice, they were looking at your eviction records. Some of them may not be truthful and pick other reasons, but they do really care about that. So ORS 105.163 was a way to combat that. Senate Bill 282 was passed during COVID, which made it a little bit easier for if you were evicted between April 1st, 2020 and before March 1st, 2021, then they made it a little bit easier for you to erase your records. And House Bill 2001, which is really, really cool bill that we're going to talk a little bit later, where the court by itself, they have to do a search and then they automatically expunge the record under some circumstances. So before Senate Bill 282, which made it a little bit easier if you were evicted during COVID, or at least the 1 year, if you had a judgment of restitution, so what that means is a judge entered the final judgment. So landlord wants to evict you, he sends you the right notice, and then you go to court. The judge hears both sides, both you and your landlord, and then decides what happens. Are you going to stay, or are you going to leave or do you have to leave and then pay some sort of fines? So you can expunge it or you can erase it if the judgment was entered 5 years before you file, at least 5 years before you file, and you have paid all the money award that's under the judgment. Now, this is really important because your landlord can say you owe $1,000, but if the judgment says you only owe $500, if you pay that $500, that's all that matters. So it doesn't matter what your landlord says. What matters is what's on the actual judgment. And the second way is if there was a judgment by stipulation, which means the judge didn't decide whether you leave your apartment or home. It was an agreement between you and your landlord. Either before you go to court or during court, you'll have time to talk with your landlord and try to come up with some sort of arrangement, whether he gives you a month to leave or he says pay $500 and you can stay. So that's an agreement. And then in that situation, they made it a little bit easier where if you satisfy, so say you agree that you're going to leave your apartment or home in a week, and then you actually leave in a week, then you can apply for the court to erase that eviction record. Or if you win your eviction case and you get to stay, so you go in front of the judge that says the landlord is completely wrong, he messed up the notice, he messed something up, and you win, so you get to stay in your apartment. So you might ask yourself, if I win, why do I really care about having that record erased? Well, future landlords can actually look at that, and sometimes even if they see that you won, they're going to see that you have an eviction case, and that might factor into whether they accept you as a new tenant. Because of Senate Bill 282, the process remains the same, but what they added was if you were evicted between April 1st, 2020 and March 1st, 2022, then you don't have to wait the 5 years, but you still have to, if the judgment says that you have to pay $500, then you still have to pay that $500, but you can apply to have that record erased almost right away. So how do you get your record erased? The first step is there's a motion where it's pretty much check the box. You have to fill in the case number, and I will talk about it in a little bit. The motion is called a motion to set aside residential eviction judgment. So say you were evicted in Multnomah County. So you have to go back to Multnomah County and you have to file that motion. And at the same time, you have to send your landlord a copy. So just think about it, even send it before you file the motion. So that same day, fill out the motion, send your landlord a copy, and then at the same time, file with the court. After your landlord receives the motion, they have 30 days whether to object, tell the court, hey, no, we don't want his records to be erased for whatever reason. If they do object, then the judge is going to set a hearing where both sides are going to go there, and the landlord has to tell the judge why he doesn't want his record erased. So if they don't object, then the judge just signs off and your records are erased. So this is the form that, and this form is in your handout. Very simple form. So the first thing is you just insert what county. So if it's Multnomah County, where the original eviction record, that's where you put the original case number that, so just look at the original judgment, just copy the case number, write the landlord's name, the tenant, your name, or whoever was on the case. And then if there's multiple tenants that were in the house, you just write your name here. And this is just explaining to the court what the law is. This is where you check the box. So did you win? Did you win, or did the landlord win? If you won, then you just check this box, and that's all you need. If the landlord won and you had to leave the apartment or home, then you check this box, and then, like I said, you have to pay whatever money award or whatever amount that you had to that was in the judgment. You have to pay that, and then the judgment has to be either 5 years old or it happened between April 1st, 2020, but before March 1st, 2022. And this part of Senate Bill 282 will expire in 2028, if not extended more. Or if it's by stipulation and then you've satisfied all the money award in the judgment. And then this is where just date it, sign it, put your address. And this one is where I said mail this copy before you file it, because you have to say that you mailed it, and you have to put in the date and other information. So this bill is actually really cool. So it's starting December 31st, 2024. Each court in Oregon has to conduct a review of eviction records, and they have to erase those records if they meet certain criteria. The criteria is you paid all your money award that's in the judgment, or the time for paying that award has expired. And the judgment, if the judge entered the final judgment, it's been at least 5 years, or if you and the landlord agree that that you're gonna leave the apartment within a certain time and the judge didn't make the decision, then it's only 12 months instead of 5 years. And it doesn't apply to any eviction that happened before 2014. And like I said, the circuit court, the judge has to conduct the review on itself, so you don't have to apply to get your record erased. Hopefully by December 31st, 2024, that process is going to start rolling. And this is just some great, just what I talked to. This is some great resources that you can access. This is going to be all provided to you. It's a handbook of how, explaining how to seal a record or erase it. And that is all I have. So,
We have some time for questions, if anyone has questions.
Hi, I had one question and I was wondering, so is there like a certain percentage that your landlord can raise the rent by each year?
I'll take this one, or no, okay, sorry. Yes, yes, there is a percentage and it changes every year. It's tied to the consumer price index. And if you give me a second here, I can pull up the amount, but this most recent year, there's been a pretty significant increase in the amount of rent that the landlord can provide. Increase it by, I believe, is 14.1. Unless you are in the city of Portland, which has its own sort of local ordinances that keeps that restricts how much the landlord can increase it by, and if they increase it by 10% or more, the tenant would also be able to request what's called relocation assistance. And if the landlord pays that, the tenant can either accept the money and move out, or they can return the money and pay the rent increase. I don't know if Kate or Amanda or Stephanie want to add anything, and I'll pull up the percentage for the current year for you, Sarah.
I think that helps, thank you.
I have question. Yes, so what is the deadline for the eviction request? Because my landlord notice for eviction for me, so it's just 2 weeks. But actually we signed the contract until the end of August. We have a roommate agreement as well.
Yeah, so first I just started with the disclaimer that we're not able to provide individualized legal advice during this workshop. I'm happy to speak more generally about just generally about evictions and terminations, but as I mentioned during my portion with terminations, it depends on the reason. I called it the type of termination notice. So it's like, what is the reason that the landlord is evicting a tenant? Depending on the reason, that is going to define how much time a landlord is going to have to provide to a tenant. But regardless of what the reason is and how much time they're giving, that notice, there should be a physical notice that you're receiving. And the materials that we've linked and sent out and talked about here, and we can, if you're eligible for legal aid services, I think you might consider contacting our office to
Okay.
Thank you for sharing the screen. Contacting our office, that's the 6th bullet point down here. Finding your local legal aid office and contacting them, and even if you're not eligible for services, to be directed to other tenant attorneys that might be able to assist.
Okay, thank you so much.
I actually had a further question about the one I asked. If they do raise your rent, how much time does the tenant have to pay that increase, or what is the time notice for you to pay and like it takes place, the new rent?
So at minimum, the landlord needs to provide 90 days notice before the rent increase can take effect. So they would have to give, for every rent increase must be preceded by a 90-day written, so physical physical rent increase notice that's given to the tenant by one of the 3 service methods that we talked about. And then it would take effect after the 90-day period has passed. And I just included the link in the chat for the rent stabilization. So each year, the Oregon agent, which agency is this? The Department of Administrative Services, based on the consumer price index, sets what is the new rent increase amount that's allowed for a year. And the Oregon statute or the law that defines that, I'll also drop that in the chat, is ORS 90.3.
And correct me if I'm wrong, but isn't it that even though that's a statewide statute, each county can make its own rules on how much rent increase? I know Multnomah County is relatively friendly towards tenants, and they can only increase it below 14.6.
So I believe in Portland is the one place I'm aware of that has
Portland, that's right, not Multnomah County, Portland, yes.
Yeah, but because of preemption, state law preempts, so I think for Portland local ordinance, it does not set a lower rent increase limit, but it requires that if a landlord goes over a certain amount, which I believe is 10%, then they are required to pay the tenant amount of money called relocation assistance, which the tenant can choose to either accept and move out because they're saying, I can't afford this rent increase, or they can return that money to the landlord and choose to stay and continue paying the amount that the rent increase amount.
Okay, thank you. I also had another question. So by written lease, it needs to be written every year or just till the expiration, written expiration on the very first lease?
I'll try to give you a break, Diane, and y'all jump in with additional detail, but take a look at your lease agreement. So some leases will say what happens at the end of the expiration. So for example, like some leases I've had before have said, you know, this lease is for a year, but at the end of that year, it goes to month to month. It goes month to month or week to week. And so then the term of the lease essentially renews every month unless something happens, like one party gives another party notice that they want to terminate whatever that relationship is. So it really just depends on what's in the lease agreement between the landlord and the tenant. Anything else to add, Diane or Kate?
Thank you.
I'll just add to that in Oregon, you don't have to have a written rental agreement for there to be a landlord-tenant relationship as well. And depending on whether it's in most cases, folks are in month to month, but sometimes they start with a fixed term lease. Maybe they sign and said that this lease expires a year later. In Oregon, I think since 2019, passage of Senate Bill 608, if you don't renew that fixed term lease, it automatically rolls over into a month to month lease.
Okay, thank you. Yeah, that was also like another part of the question. That makes sense. Thank you.
Any other questions?
right. We might be there. I might steal screen share again here for one moment, just to make sure everybody kind of sees again. If you want access to any of the presentation materials you saw today, it is on our OregonTrio.org website, and then under events, renters rights workshop, all of these PDFs are linked here, both in English and Spanish. And you can kind of go, but it's probably a lot of information, right? Like we put a lot in there because we want to cover a broad spectrum of stuff here in one place and just give you can go back and view the recording, look at the materials, but definitely know kind of on those resource page that there are definitely organizations and folks out there that can help you navigate some of these processes, right? If you qualify for those programs. So yeah, any kind of final words from any of our presenters here today?
Thank you for letting us come and talk with you guys.
And also, if you don't fall into the income requirements that can qualify you for some of the free services, it's always worth a shot to call the Oregon State Bar and see if they can refer any attorneys that might be able to help you out with low cost or even pro bono in some cases for this free service that attorneys provide. So it's always worth just calling the Oregon State Bar full services and asking if they have anyone that can provide help if you don't fall within the income requirements.
Wonderful. Of course, we pick like the most absolute beautiful day humanly possible for 7 o'clock. That was not our intent when we initially planned this out a month and a half ago. So I appreciate those of you who are here despite the lovely day outside. Thank you again. I hope you all have a wonderful rest of your evening. Thank you.
Thank you. You too. Bye-bye.
Thank you. Take care.
Thank you.